Have you ever felt it? That tiny, fleeting moment of hesitation, your cursor hovering over a single, simple button. 2 words staring back at you from the screen. I agree. It's a gateway to a new app, a new service, a new connection. And in that split second, a silent, invisible transaction takes place. You get what you want. But what do they get? What have you, in that mindless, reflexive click, just promised them? We tell ourselves it's nothing, that it's just legal jargon, a formality nobody actually reads. But what if it's not? What if it's a contract, a binding agreement, written in the shadows by a team of lawyers whose only job is to protect their company, not you? What if inside those thousands of words of dense, impenetrable text, you've just given away a piece of your life, your privacy, your money, your rights, your story? What if you've agreed to be watched, to be manipulated, to be silenced? We treat the terms and conditions as a joke, the biggest lie on the internet. But the terrifying truth is, they aren't kidding. And the loopholes hidden within them are not just gross, they are a masterclass in psychological and legal warfare, waged against every single one of us. And today we're going to step through the looking glass. We're going to read the fine print. The digital world we inhabit is built on a foundation of these agreements. Every social media profile, every smart device in your home, every free trial you've ever signed up for, it all began with a click. And with that click, we invited ghosts into our machines. Phantoms that watch our every move, listen to our conversations, and take notes. Consider the terms you agree to when you download that fun new photo editing app. Buried under a section titled User Content License, you'll almost certainly find a clause that looks something like this. You grant us a perpetual, irrevocable, worldwide, royalty-free, and non-exclusive license to use, reproduce, modify, adapt, publish, translate, create derivative works from, distribute, perform, and display such content. Let's break that down, because every word is a weapon. Perpetual and irrevocable mean forever, and you can never take it back. Even if you delete your account, they can keep your photos. Worldwide means they can use them anywhere. Royalty-free means you will never be paid a single cent. You post a beautiful photograph of your child. You think you're sharing it with family, but you've just given a faceless corporation the right to use that photo in an advertising campaign in another country, 10 years from now, without your permission and without paying you. You don't own your own memories anymore. They do. But it gets so much deeper. Many apps, especially free ones, include the right to access your device's microphone. The official reason is always innocent, to enable voice commands or other features, but the language is often deliberately broad. A clause might state the app has the right to record audio at any time without your confirmation. They say it's for improving the service, but have you ever talked about something obscure with a friend, only to see an eerily specific ad for it pop up on your phone an hour later? Companies will swear on a stack of legal documents that they don't do this. They say it's a coincidence, a result of sophisticated predictive algorithms. But the permission is right there, in the contract you agreed to. You gave them the key, and you're asking them to promise they won't use it to listen at the door. It's a digital wiretap you installed yourself. Then there is the specter of your location data. We've grown accustomed to apps asking for our location to provide services maps, weather, ride-sharing. But the loophole is in the fine print. You might set the permission to only while using the app, thinking you're in control. But the terms can include the right to collect, use, and share precise location data, including the real-time geographic location of your computer or device. Even more insidiously, some clauses allow for the inference of your location through other means. The Wi-Fi networks you connect to, your IP address, Bluetooth signals. You can turn your GPS off, but you can't hide. They know the route you take to work. They know you visit a coffee shop every Tuesday. They know when you're at a doctor's office or a therapist or a protest. This data is then anonymized and sold to data brokers. But re-identifying someone from anonymous location data is shockingly easy. Your daily patterns are as unique as a fingerprint. They're selling a map of your life to the highest bidder, and you agreed to it in exchange for a game where you match colorful candies. This constant surveillance creates what we call the data body, a digital twin of you, assembled from scraps of information you unknowingly surrendered. Every like, every search, every private message, every photo. The terms of service often give the company the right to analyze this data, to create a profile of you, your political leanings, your sexual orientation, your mental health status, your secret insecurities. This profile is their most valuable asset. They use it to sell you things, to shape what news you see, to influence how you think and vote. You've agreed to let them build a psychological model of you and then use that model against you. You think you are the customer, but you are the product being sold. The service isn't free. The price is you. If the digital surveillance feels like a quiet, creeping violation, the financial traps are a far more immediate and visceral kind of pain. They are designed to exploit our forgetfulness, our aversion to confrontation, and our simple inability to navigate the bureaucratic mazes they create. The most common and infuriating of these is the auto-renewing subscription, with an impossible cancellation process. It's the free trial that wasn't free. You sign up for a service, enter your credit card details, just for verification. They promise, and then promptly forget about it. A month later, a charge appears on your statement. You try to cancel, but the cancel subscription button is nowhere to be found. Instead, the terms you agreed to laid out a very specific and very difficult path. You might have to call a customer service number that is only open for 3 hours a day on weekdays. You might have to send a certified letter to an office in another state. They have created a system where the cost of your time and frustration is greater than the monthly fee, so most people just give up and let the charge recur. It's not a mistake. It's a business model, legally sanctioned by the terms you accepted. Hidden deep within the pricing section is another insidious clause, the right to change pricing at any time without notice. You signed up for a service at $10 a month. A year later, it's $15, then $20. They don't have to email you. They don't have to notify you. Their only legal obligation was to put it in the original terms, which they know you didn't read. They are banking on the fact that you won't notice the small increase, or that if you do, it won't be enough to make you go through the hassle of canceling. It's a slow bleed, a corporate parasite siphoning money from your account, and you gave it permission to attach itself. Then there's the practice of dynamic pricing. ID. The terms will often state that prices are subject to change based on demand, time, or other factors. What this means is that the price you're offered is not the same price everyone else is offered. It's based on that data profile they built of you. Do you live in a wealthy neighborhood? The price goes up. Have you searched for the same flight multiple times? The algorithm flags you as desperate, and the price goes up. Are you shopping from an expensive brand of smartphone? The price goes up. They are using your own data to charge you the absolute maximum you're likely to pay. It's a personalized penalty for being you, and it's all perfectly legal because of a single sentence you scrolled past. But perhaps the most fundamentally unjust of all financial clauses is forced arbitration. This is a big one, and it's terrifying. Buried in the text, you'll find a clause stating that you agree to waive your right to sue the company in a court of law. Instead, any dispute you have must be settled through a private, binding arbitration process. This sounds fair, but it's a rigged game. The company often gets to choose the arbitration firm, which has a financial incentive to rule in favor of the company to get more business. The proceedings are private, so there's no public record of wrongdoing. And the decisions are almost impossible to appeal. So if the company's product injures you, if they commit massive fraud and steal your money, if they ruin your reputation, you cannot take them to court. You can't get a jury of your peers. You have to go, alone, into a private room and argue your case in a system designed by them, for them. You have signed away your access to the justice system, and often coupled with forced arbitration is another clause, the class action waiver. This is the knockout blow. It says that not only can you not sue them, but you can't join with other people who have been wronged to sue them together. A class action lawsuit is one of the most powerful tools ordinary people have to hold massive corporations accountable. One person overcharged by $5 is not going to hire a lawyer, but 1 million people overcharged by $5. That's a $5 million lawsuit that can force a company to change its ways. By forcing you to waive this right, they ensure they can get away with small-scale, widespread abuses, knowing that no single individual will ever have the resources to challenge them. It's a license to steal, a few dollars at a time, from millions of people. And we all just click, I agree. Beyond the invasions of privacy and the financial traps, there is a third, perhaps more profound category of loopholes, the complete and total surrender of your fundamental rights. It's in these clauses that the sheer imbalance of power becomes chillingly clear. You are not entering an agreement between equals. You are accepting terms of surrender. One of the most common is the limitation of liability clause. In essence, this section is a company's attempt to immunize itself from any and all responsibility for anything that could possibly go wrong. The language is often breathtakingly broad. In no event shall the company, its directors, employees, or agents be liable for any direct, indirect, incidental, special, or consequential damages resulting from the use or the inability to use the service. What this means is that if their servers get hacked and your most sensitive personal information, your address, your social security number, your private messages is leaked to the world, they are not legally responsible. If a bug in their smart home software causes your heating to fail in the middle of winter, leading to burst pipes and thousands of dollars in damage, they are not responsible. They will put the entire onus of security on you, while simultaneously absolving themselves of any consequence for their own negligence. You are accepting all of the risk, and they are accepting none. Then there is the concept of ownership, which has become treacherously blurry in the digital age. When you buy a book, you own it. You can lend it, sell it, or keep it forever. But when you buy a digital movie, a song, or a piece of software, you are not actually buying it. The End-User License Agreement, or EULA, that you click through makes this very clear. You are purchasing a license to use the content, a license that the company can revoke at any time for any reason. A clause will state, the company reserves the right to modify or terminate the service at any time without notice. People have woken up to find their entire library of hundreds of purchased movies has vanished overnight because a company decided to discontinue its service. There are no refunds. There is no recourse. You didn't buy a product. You paid for a temporary privilege, and you agreed that the privilege could be taken away. You own nothing. These agreements can even control your speech. Many online platforms, from social media to video games, include clauses that give them the right to suspend or terminate your account for violating their community standards. While this is necessary to curb hate speech and harassment, the terms are often written so vaguely that they can be applied to almost anything. Phrases like behavior that we deem inappropriate or content that is otherwise objectionable are legal carte blanche. They can silence dissent, remove criticism of their platform, or deplatform you for political views they disagree with, all under the legal umbrella of the terms you consented to. You are not exercising free speech on their platform. You are a guest in their house, and you have agreed that they can kick you out for any reason or no reason at all. And as we venture further into the strange landscape of terms and conditions, we find clauses that seem to be pulled from the pages of a dystopian novel. They are the bizarre, the outlandish, the darkly humorous reminders of how little power we have in this digital feudalism. For years, the UK video game retailer GameStation famously included a clause in their terms that read, "By placing an order via this website on the first day of the 4th month of the year 2010, Anno Domini, you agree to grant us a non-transferable option to claim, for now and forevermore, your immortal soul." Thousands of people agreed. Of course, it was an April Fool's joke, and they included an opt-out link for those who noticed. Only a tiny fraction did. It was a brilliant, terrifying experiment that proved their point. Nobody reads this stuff. And if you'll agree to give away your soul, what else will you agree to? In the real world, the clauses are less funny. DNA testing companies have terms that can grant them sweeping rights over your most personal information. Your genetic code. You send in your saliva to find out about your ancestry, but the terms you agree to may give them the right to sell your anonymized genetic data to pharmaceutical companies for research. You have essentially become an unpaid, unknowing participant in a massive medical study. And what happens if that data is ever breached or re-identified? Your genetic makeup, your predisposition to diseases, your entire biological blueprint could be out in the open. Some terms and conditions for social media and content creation platforms include a likeness clause. It grants them the right to use your name, your voice, your photograph, and your likeness in connection with their service, often for promotional purposes, forever, with no compensation. You post a smiling selfie, and you could unwittingly become the face of their next ad campaign. Your identity becomes their marketing material. There are even clauses that force you to lie. Some software EULAs have included sections that prohibit you from publishing negative reviews or benchmarks of their product. To use the software, you have to legally agree not to criticize it publicly. It's a forced silence, a non-disparagement agreement you sign before you even know if the product is any good. So what can we do? It can feel hopeless. We can't spend hours reading tens of thousands of words every time we download an app. But being defenseless is not the same as being powerless. The first step is awareness. It's understanding the game that is being played. The goal of these documents is not to be read. It is to provide legal air cover for practices that would be unacceptable if they were stated in plain language. They are designed to be ignored. So we must learn to stop ignoring them, at least not entirely. We can learn to spot the red flags. Look for those keywords: perpetual, irrevocable, waive, sole discretion, without notice. These are the markers of a one-sided agreement. Use tools. There are services online like TOSDR, Terms of Service, Didn't Read, that use a community of volunteers to read and grade the terms of major websites, giving them a simple rating from very good to very bad, and highlighting the most egregious clauses. It's not perfect, but it's a powerful shortcut. It's like having a crowdsourced lawyer look over your shoulder. We can also exercise our power as consumers. Choose services that pride themselves on having clear, simple, human-readable terms. Support companies that compete on privacy and respect for their users, not just on features. When a company is caught with an abusive clause in their terms and there is public outcry, they often change it. Our collective voice matters. We have to make it clear that treating customers with contempt is bad for business. And finally, we must advocate for change at a higher level. Laws like Europe's GDPR have begun to shift the balance of power, forcing companies to be more transparent and giving users more control over their data. We need stronger, clearer legislation everywhere that sets a baseline for fairness in these digital contracts. An agreement where one party has all the power and the other has no choice but to click agree is not a fair agreement. It is coercion, elegantly disguised as consent. The world is not going to slow down. The pace of technology will only accelerate, and with it will come new services, new devices, and new, even more cleverly worded, terms and conditions. The silent contract we sign every day is not going away, but we can change our relationship with it. We can move from being passive, unknowing participants to active, critical, and mindful users of technology. We can't read every word, but we can understand the stakes. We can protect ourselves, and we can demand better, because in the end, that little box isn't just asking for your agreement. It's asking for your trust. And trust, unlike a license or a piece of data, must be earned. The next time your cursor hovers over those two little words, just pause. Take one extra second. Think about the invisible transaction that's about to take place. What are you getting? And what, in the endless, unread pages of fine print, might you truly be giving away? Is it a price you're willing to pay? If this journey through the dark corners of the internet has opened your eyes, then our conversation is just beginning. There are countless other hidden systems that shape our world, and we plan to uncover them all. Subscribe to continue the exploration and share your own experiences in the comments below. What's the most outrageous thing you've ever found in the fine print? Let's learn from each other. Stay vigilant.